Hello everyone and welcome to another edition of our video newsletter. In this video I want to answer a question that was asked of me, which is, can I use the Baker Act to treat a family member who has an issue with alcohol? And the answer to that is no, but if there's an emergency you should call 911. So as I've said in a number of my other videos, the Baker Act is not a treatment statute. It is a statute that is designed specifically for one purpose and one purpose only, which is emergency stabilization. Now, I get a lot of calls about people wanting to use the Baker Act to treat people, and I tell them, unless it's an emergency, in which case you should always call 911, I strongly advise that you don't use the Baker Act to try and treat somebody. So what typically happens is the family calls the police, or they go to the courthouse and they file a petition under Chapter 394, which is the Baker Act. And what they do is they get the petition granted, the police go out, they pick somebody up, and now the person's at a Baker Act receiving facility. Well, after 72 hours, the facility is free to file their own petition, known as a petition for involuntary placement. And then they basically, what they do is they ask the court to allow the state to step into your shoes or the petitioner's shoes and brush them aside, and now the state only is going to make medical decisions and clinical decisions for the person you were trying to get help for. So if it's an emergency, of course, call 911. If someone is threatening to harm themselves or hurt somebody else, absolutely. That's the whole point of the Baker Act, right? For an emergency situation. But if you're trying to get somebody into treatment, please, please, please don't use the Baker Act. That's not what it's for. We have the Marchman Act statute on the books here in Florida. We have a great guardianship statute, and we can also look to do perhaps some type of intervention. So with that said, thanks once again for this question. Take care and be safe.